Maybe we'll wear the grumpy cat hat. What do we think? Because if I was Afroman, I would be grumpy as well. So the news is reporting, that Afroman is being sued by some police officers in Ohio who raided his home, I'm assuming with a warrant and otherwise properly. And then other stuff ensued, but ultimately he had recorded the encounter. I don't think he was home at the time, but his security cameras caught it, and I think his wife had made some video as well. And he made a music video out of it, and he's released the music video, quote unquote, for commercial purposes, according to the lawsuit filed by the police officers who feel like their commercial likeness or their use of their likeness or their privacy was violated or something. Now, I'm a copyright attorney, so I can talk all day about copyright, and this is not really a copyright issue. If Afroman's cameras captured the security footage of the raid, then he owns the footage by default. Now, you could make arguments that security footage isn't really a creative thing. You just sort of point a camera and record facts. You're not setting up a scene. You're not writing a script. So it's not really creative. You're recording something that's factual. But photography is protected by copyright. You do have to choose a lens and choose a camera, choose where you want to point it and all that. And, if you said that facts can't be copyrighted, well, how do you protect a wildlife photo or a background, a scenery photo or something? It's just how the scene existed at that time. No, the courts protect the photographer for choosing to record that particular image at that particular time with a focus and settings on the camera, aperture, shutter. A lot of these things are automatic these days. And there is, of course, where you go too far, you can't have an AI create a photo. But somewhere in there, security camera footage is still copyrightable, in at least this professional's opinion. And even if it wasn't, that really wouldn't change whether you can publish something that's not copyrightable. So Afroman can certainly use something that's not copyrightable to make a YouTube video or a music video out of. So copyright's not an issue. Great. Everybody have a nice day. Thank you for coming to my talk about Afroman. So it's not interesting as a copyright story, but it is interesting as a why in the heck do the police think they can make a claim for privacy rights or likeness rights? When someone appears in a movie, when Patrick Stewart appears in Picard, in Star Trek Picard, which me and my wife are currently very much into, he has the right to not have his likeness published without his permission. So there's a contract. Obviously, he is represented by an agent or agency, and they're going to work on the contract for him. Every actor is going to have a whole contract. But the basis behind that is a couple things. You can't just record somebody and make money off of their likeness. But you can record people in public in the US, and as far as I know, you can publish that video for the most part. So when does it cross the line from recording something in public and that being legal and recording someone's likeness to then using it for such a commercial purpose that it is illegal? And so that's what I thought we would look into today. And I actually don't know a heck of a lot about it myself, so I thought we would do some of the legal research together, and I could show you a little bit about how I would go about figuring this out. So my first thought, one of the things they want you to focus on in law school, and one of the things I would want you to focus on as an audience interested in the law, would be issue spotting. Can you spot the legal issues? So what legal issues did we just talk about? Copyright. Okay. I can look at the publication of something on YouTube, online content, publication of something on various platforms. Obviously it's going to be distributed via major music distributors and things like that. That's going to have copyright, so I spotted that. But we also can think about the privacy rights of the officers, because that's what they put in their lawsuit. So there's some issues to spot there. We have to evaluate every single one of those. And then one that's not mentioned in the obvious copyright issue to me, or the privacy lawsuit from the officers in the Ohio Common Pleas Court, the county court, is First Amendment. So there's going to be also an evaluation of, does Afroman have a First Amendment right to publish these things? Is there an exception, or does First Amendment law preempt or overcome the state privacy laws that are being asserted here? So we have to look up all those things to try and figure out the answer to this problem. First, the lawsuit's not very complicated. Let's take a quick look at it. I do have a redacted copy here because as much as the officers protected their addresses by using their attorney's address, they did not hide Afroman's addresses. So I thought that was a little one-sided of them. This was filed in Adams County, Ohio, the Court of Common Pleas. So that's a state-level court that operates at the county level. Their jurisdiction is going to be a county, the county of Adams County. Filed March 13th at 3:59 p.m. And there's 7 officers versus Joseph Edgar Foreman, a.k.a. Afroman, Hungry Hustler Records, Media Access, and 3 John Does. They state, on or about August 21st, 2022, law enforcement officials from Adams County Sheriff's Office conducted a search of Foreman's Adams County residence pursuant to a lawfully issued search warrant. Foreman was not present at the time, but his wife was in the home, observed the search, and recorded portions of the search on her camera phone, including the faces and bodies of many of the law enforcement officers involved. Foreman's residence was equipped with several security video cameras, which also recorded many portions of the search, including the faces and bodies of many of the law enforcement officers involved. After the search was concluded, Foreman used portions of the recordings of the search from his wife's phone and his surveillance cameras to create music videos about the search. These music videos clearly portray the images, likenesses, and distinctive appearances of many of the officers involved in the search, including those of all plaintiffs. Foreman created dozens of videos and images of plaintiffs' personas and posted them on various social media platforms, including Facebook, YouTube, Snapchat, TikTok, and Instagram. Foreman continues to use the videos and photos of the plaintiff's personas for commercial purposes to promote his Afroman brand, sell products, promote his music tours, and to make money from the use of plaintiff's images on videos and other media. Following are some of the many examples. So there's a post containing an image of Foreman wearing a shirt with an image of plaintiff Sean Cooley, besides an image of Peter Griffin. Caption, "Good morning, ladies. What up, fellas? Congratulations to police officer Poundcake. Thank you for getting me 4.5 million hits on TikTok. I couldn't have done it without you, obviously." And then they have a link to that post. Let me see if I can bring that up here. That's the image. So he's using this officer's image on a t-shirt next to Peter Griffin, obviously making fun of, mocking the officer who raided his house. You know, how would you feel if officers raided your house? So, but, you know, feelings, the law doesn't care about your feelings, usually. Let's continue with our evaluation here. Instagram post containing images of fans holding merchandise that contains images of Sean Cooley, caption, "Lemon Pound Cake." So here we go. Here's 3 of the officers with Peter Griffin and a lemon pound cake, and it says, "Officer Pound Cake." There's more, by the way. What's your favorite song on Lemon Pound Cake so far? What's your favorite line? This was another post that he made showing the officers or sheriff's images. And it continues, "I am pressing up merchandise for my up-and-coming Canada tour. Which Officer Poundcake shirt do you like the most, the one on the left or the right? I need to know to invest my money in the more popular shirt. Canada, get ready for the most hunted to most wanter, the most blunted rapper in the world. For the first time, I will have brand new merchandise." So he is doing more than just making a YouTube video out of it, but he's also selling merchandise with their images on it. There's an interview on Vlad TV during which Foreman discusses the use of the search as material for the song. Foreman admits to using images and clips from the search in videos and promotions. Foreman states, "Will you repair my door?" was a song that went viral. His lemon pound cake clip went viral. Everybody understood what I was talking about when I said lemon pound cake. That's the cop on the viral video, TikTok, that was going through the house that wanted a slice of the lemon pound cake. Oh, so there was an officer who asked for a slice of cake. Wow. So that's how that's there. So this sounds an awful lot like it's First Amendment versus, officers' right to privacy of their likeness. You do have a right to keep your likeness from being exploited like this. If someone took a picture of you on the street, yeah, they probably can post a video of something that happens on the street, but can they make merchandise out of your cutout from the street? That's a really interesting question, and I'm not going to approach it with the idea that I already know the answer. I could see how taking Billy Joel's picture on the street, paparazzi just takes his picture, publishes an article that says, "Hey, we saw Billy Joel on the street today." Okay, that's legal. But what about taking a cutout of Billy Joel's image and selling it on your t-shirts? That is a different situation, and it needs to be evaluated differently. He continues, or should I say the complaint continues, with more Instagram posts, Adams, KK County, get my new album, Lemon Pound Cake, etc. So he's taunting them. This is the judge that signed the warrant. His name is Roy Droopy Gabbert. Vote him out before he signs a fictitious warrant and sends someone some overreacting cops, KKK cops, to your house, jeopardizing the lives of you and your family. Yeah, I feel in a way about overactive or overreactive police officers. Was there really a justification for raiding this man's house? I don't think you really need to raid people's houses with armed police officers unless there's something really, really bad going on and you've got some really, really good basis to do so. And from what I understand, they found nothing during this search. So it was also, in some way, false information. And was it the police that relied on false information? Were they willfully blind to a false report? Did they go off insufficient information? Do all I have to do is call and say, "Hey, I think somebody's doing something illegal at my neighbor," and they'll go raid Afroman's house because that's all they wanted to do it in the first place? So he's rightly ticked off if they didn't have any basis for this. There's more. There's pages and pages of him using these. Foreman created, performed, posted, and publicized these and other depictions of plaintiffs' personas for commercial purposes through or in cooperation with or with the assistance of other defendants, I guess the corporate defendants and the John Does that they don't know who they are yet. Defendants' actions were willful, wanton, malicious, and done with conscious or reckless disregard for the rights of plaintiffs. As a result of defendants' actions, plaintiffs have been subject to ridicule, even in further performance of their official duties by members of the public who have seen some of the above postings. In some instances, it has made it more difficult and even dangerous for plaintiffs to carry out their official duties because of comments made and attitudes expressed to them. The people make comments. That means it's dangerous to do your duties as a police officer. Yeah. Very, very thin-skinned police officers, if I may add. As a further result of defendants' actions, plaintiffs have been subject to threats, including death threats by anonymous members of the public who have seen some of defendants' above described postings. Okay, so obviously death threats or threats of any kind are the line. You don't cross that line. You don't make death threats. You don't make threats of physical violence or anything like that. We can use our words, and our words are that this was a ridiculous raid, and Mr. Afroman is right to be upset about it. And I don't like when plaintiffs include this. Unless Afroman is connected with the threats, unless he's the one making the threats. No, he's the one mocking the officers. You're allowed to mock the officers. That's a Constitution-given First Amendment right. You have no limit on your right to mock the officers. Now, whether he can mock the officers by putting their faces on t-shirts and selling those t-shirts, we're going to get to that. As a result of defendants' actions, plaintiffs have suffered damages, including profits derived from and attributable to defendants' unauthorized use of plaintiffs' personas, and have suffered humiliation, ridicule, mental distress, embarrassment, and loss of reputation. Plaintiffs continue and will continue in the future to suffer damages unless defendants are enjoined. In other words, an injunction, a court order preventing further violations of plaintiffs' rights. So count one is unauthorized use of an individual's persona, and the chapter of the Ohio revised code. I'm hoping that's not revenue code. Revised code, chapter 2741. We're going to look at that. Defendants used the personas of plaintiffs for commercial purposes. During plaintiffs' lifetimes, without their authorization to do so, the personas were not used in connection with any news, public affair, sports broadcast, political campaign, and their unauthorized use of plaintiffs' personas for commercial purposes was not justified or excused. Now, why would they say something like that? This is them trying to address an exception to the law. We'll get to that in a second. Plaintiffs have been damaged, willfully, everything there. So that's the end of count one. Count two is for invasion of privacy. Defendants have appropriated the reputation, prestige, social standing, public interest, and other values of plaintiffs' names and likenesses, which have intrinsic value in contravention of plaintiffs' right to privacy. So we're going to talk about your right to privacy, and you need to have a reasonable expectation of privacy. These plaintiffs, these police officers, have suffered embarrassment, ridicule, emotional distress, humiliation, and loss of reputation, and are entitled to injunctive relief. Another invasion of privacy count three, false light, that they have been depicted in a false light that defendants knew to be false and which portrayed plaintiffs in a false light, subjecting them to undue ridicule, embarrassment. So was the ridicule undue? We'll talk about that too. Unreasonable publicity given to private lives. Defendants gave the publicity of the above matters concerning private lives of plaintiffs, which were not of legitimate concern to the public. And then they asked for injunctive relief that these plaintiffs are suffering irreparable injury. That's the standard for these things. Irreparable injury to their reputations, mental health, legally protected rights. Some injuries need to be monetary to be irreparable, or need to be more than monetary to be irreparable. Mental health, I don't know if that's one that's recognized, but yeah. The injunctive relief is not adverse to the public interest, and they ask for damages in excess of $25,000, which I'm assuming is the threshold to get you into common pleas court. Otherwise, you may have to go to a lower court, like a magistrate court. So, yeah, that's why they all say $25,000. And attorney Robert A. Klinger thinks he has a good faith basis in law, in fact, to file this complaint. So let's go back here. Find the first count one. Unauthorized use of an individual's persona. So where I would start if I were to be researching this, where I did start, was by going to one of my legal research engines and asking it some questions. Now, I don't know if you're aware, but everyone is clamoring to make AI chatbots, AI artificial intelligence, do things with new industries, all based on things like ChatGPT-4, I guess Google's Bard, although I'm not impressed with it yet. I haven't seen Microsoft's use of these things in Copilot yet, but I do have access to something called CoCounsel, which they gave me for free for a week. And I asked it a few questions. One, I asked it to summarize the Afroman lawsuit. Here's how good of a job it did. Pages 1 to 8, the document is a legal complaint filed against musician Joseph Edgar Foreman, Afroman, and several associated entities. The plaintiffs are 7 law enforcement officers from the Adams County Sheriff's Office. The complaint details a search of Foreman's residence. Foreman used these recordings to create music videos that featured plaintiff's image and likeness. The complaint provides several examples, including Instagram posts, YouTube videos, and merchandise. So that's a pretty accurate summary, I think. And then the rest of the complaint cites the counts violated or prohibits, the law prohibits an unauthorized use of an individual's persona for commercial purposes. The complaint also alleges an invasion of privacy, that the actions were willful, and seeks monetary damages. So that's a good 10-paragraph summary, I think. And then I asked it to research the First Amendment and the right to publish police videos for commercial purposes. And this was its answer. The majority of cases cited here affirm that citizens have a First Amendment right to record police officers performing their duties in public, subject to reasonable time, place, and manner restrictions. However, some cases suggest that this right may be limited in certain circumstances, such as when the recording interferes with police activity, when it is surreptitious, or is done by the subject of the police activity. Additionally, some cases address the constitutionality of state statutes that criminalize the recording of police officers and generally find that such statutes violate the First Amendment. While these cases do not specifically address the commercial use of recordings, they do suggest that the act of recording police officers in public is generally protected by the First Amendment. Further research may be necessary to determine whether any cases specifically address the commercial use of such recordings. And then it gives me 15 pages of citations. So here's Fields versus City of Philadelphia from the Third Circuit, which does not apply to... Wait, is the Third Circuit Ohio? The Third Circuit is not Ohio. It's Pennsylvania, New Jersey, and Delaware. The Sixth Circuit is Ohio. So when we read this, it would be prudent to look at Sixth Circuit cases. But this case, Fields, directly addresses the First Amendment right to record police officers performing their official duties and discusses the importance of protecting the act of creating such recordings in order to preserve the value of the recordings as expressive material. The majority cites to a 2011 article of Seth F. Kramer, which he notes, given the ubiquity of personal electronic devices with cameras, we live, relate, work, and decide in a world where image capture from life is routine and images captured are part of ongoing discourse, both public and private. The First Amendment protects actual photos, videos, and recordings, and for this protection to have meaning, the amendment must also protect the act of creating that material. Restricting the use of an audio-visual recording device suppresses speech just as effectively as restricting the dissemination of the resulting recording. So there we go. There's some useful text from Alvarez that restricting the recording is also effective at restricting the dissemination of the resulting recording, which we can, I think, fairly read in the reverse, that you also shouldn't be restricting the dissemination of the recording, as that is also part of your First Amendment right. Both precedent and first principles demonstrate that the First Amendment protects the process of capturing inputs that may yield expression, not just the final act of the expression itself. So there is First Amendment protection for the final act of expression. And remember, they're not arguing that they got recorded, and I'm not sure how they could. It's not their property. They're exercising their official duties as police officers. So then I need to know where a right of privacy comes into this for the police officers. Now, maybe there's a right to privacy against the commercial publication of their images. Maybe. We're evaluating that. But there certainly is no right to privacy as in a right to have a private conversation or right not to be recorded if you are executing your police duties, your official duties, executing a warrant on a house. The homeowner has the right to record you. I would even go so far as it's a good idea for the homeowner to record you. In this case, there's an accusation that the police took more money than they returned. And whether you think that's theft or not, I'd want you to read the facts. The police claim that they simply miscounted the amount of money they took and they returned the money they took. But that also could just be an easy way to cover up a theft, couldn't it? I'm not accusing anyone of anything, but the police don't have a great reputation on this one. The threat of arrest remains a potent deterrent to spontaneous photographers. We're not really talking about we're not talking about criminal prosecution for recording here. Let's see, here's ACLU versus Alvarez out of the Seventh Circuit. This case directly addresses the constitutionality of a statute that criminalizes recording of police officers. The Illinois eavesdropping statute restricts a medium of expression commonly used for the preservation and communication of information and ideas, thus triggering First Amendment scrutiny. Now, don't forget, this is a common pleas court state law claim, but the First Amendment preempts claims that overlap with it. So if the police officer's privacy claims run into the First Amendment will win. And there has to then be an exception to Afroman's First Amendment right to record police and publish the video. The real question for me isn't whether he was allowed to record the security footage and publish the security footage. He's probably even allowed to use the security footage like to make his YouTube video or make his music video. But I'm really stuck on whether he can cut out their images from the video and put them on t-shirts. However, he is expressing his displeasure at the raid on his house. This is not a Toyota dealership taking a police officer's picture and putting it on their advertisement. Imagine a billboard. Imagine this officer's image on a billboard. Imagine these officers' images on a billboard, these images being taken not from Afroman's cameras, but let's say that someone took the images on the street. Perfectly legal to take the image on the street, but then they post this cutout on a billboard and say, visit your local Toyota dealer, we love officers or something. I don't know. They're going to make a catchphrase or they're going to tie the officer's picture to it in some way. But the officer's image is being used on a billboard to sell Toyotas, which have nothing to do with the officer didn't raid a Toyota dealership and the Toyota dealership is fighting back. That would be a direct use of someone's likeness in an illegal way, I think. I think that's a much clearer example. Here in this image, he's putting these officers' image on a t-shirt, both to profit, but also to express himself, to express his displeasure at these officers raiding his home while he wasn't there with a warrant for something that wasn't there to get him in trouble for something he didn't do. They invaded, I understand that he's not sovereign. We're not doing the sovereign citizen thing. He's not a sovereign citizen, but that's his castle. That's his home. That's where you're supposed to be the most protected and have the most First Amendment rights, the most Third Amendment rights, the most Second Amendment rights, the most Fifth Amendment rights. I don't see how you could really infringe the officer's rights. They're the ones going to his house on more or less a false warrant or an unsupported warrant. Maybe they thought it was supported at the time, and maybe they're in the clear. Maybe they have qualified immunity on that one. But come on, doesn't Afroman also have the right to fight back with his First Amendment rights? He's fighting back in a way that we've agreed he's allowed to fight back. He's not going to be a vigilante. He's not going to make threats. He's not going to ask others to make threats. He's not going to offer physical violence. No. He's going to do it in a civilized way under his First Amendment rights. That's what we want. We want people to be peaceful in their retaliation. They want his retaliation to be with his words and not with his violence. So that's arguably the physical invasion of his privacy, the physical invasion of his home is a violent act, is a very, very violent act and should really only be done if it was truly necessary, which I'm already very skeptical of this. Very, very skeptical. Let's continue a little bit here on this, and then we'll move on to the persona cases. Let's see. Here's First Circuit. Right to record police officers affirms the right to record, right to record. I'm looking for the right to publish. Right to secretly record police. So yeah, First Circuit says you can secretly record police. 11th Circuit, right to photograph. And remember, above it said that along with the right to photograph is also the right to publish. Here's the Eastern District of North Carolina. That is 4th Circuit. The right to record and live stream. The court ultimately concludes that while a citizen was entitled to record, he was not entitled to live stream. This case is relevant to the research because it addresses the limits on a citizen's right to record and disseminate interaction with law enforcement. As police officers approached the car, Sharp began recording and live streaming the traffic stop from inside the car. Officer Helms told Sharp that he could record the traffic stop, but not live stream the traffic stop from inside the car during the traffic stop. As explained below, assuming, without deciding that the First Amendment entitled Sharp to record the traffic stop, the First Amendment did not entitle Sharp to live stream the traffic stop from inside the car during the traffic stop. If you're recording, that's fine. We record too. So in the future, if you're on Facebook Live, your phone is going to get taken from you. And if you don't want to give up your phone, you'll go to jail. Okay, so that might be right or wrong, but that is at least defining a line where it is considered by this court, at least, the Eastern District of North Carolina, it's disruptive enough to live stream during the traffic stop. Not to record, recording is fine, but to live stream would be too much. Is that analogous to editing the recorded video and posting it later? No. I think you still have every right to post the recording later. Maybe you can't live stream the traffic stop, especially if you're the one like operating the camera. I think that's a big difference. Here's Southern District of New York, First Amendment right to record police officers in a public space. Several circuit court decisions have found a right to exist. Does not specifically address commercial speech. New Jersey, right to record police. You can make somebody stand over there and record. They can't record so closely. Okay, so he was standing with a group of observers. The officer pointed to an area that was further from where the group was standing and stated, "You can videotape over there." As an exhibit to his opposition, plaintiff filed a copy of the video he recorded, which will ultimately shed light on whether plaintiff's claims are viable. So that sounds like it was on some kind of a motion to dismiss or something. District of Maryland, police seizing video recordings of public activity in order to prevent its dissemination. The deputies had suppressed the paper because they disagreed with its viewpoint, making their violation more blatant. Here, as discussed above, the video recording of public police actions is an activity protected by the First Amendment, so it follows that the recording itself is First Amendment protected material akin to a film or written publication. The court holds that the First Amendment protects against the seizure and retention of a video recording if the seizure was for the purpose of preventing dissemination. So you're allowed to disseminate, and again, that's Maryland. Maryland is going to be the Fourth Circuit. Still no Sixth Circuit case here. Texas, 11th Circuit, Florida, Ohio. Hills v. Davis, 2022. Plaintiffs have alleged facts demonstrating that they face a credible threat from the city's no recording policy. The court concludes that plaintiffs have standing to enforce a pre-enforcement challenge. In their complaint, plaintiffs bring two claims under the First Amendment. The first claim is that defendants' no recording policy violates their First Amendment right to record public officials. The court is not convinced that the public forum analysis applies here because that analysis focuses on the government's interference with a plaintiff's speech or other express activity, and the act of merely recording a government meeting is not an expressive activity. Although access cases are rooted in First Amendment principles, they have developed along distinctly different lines than have freedom of expression cases. So that says to me, since what he's released is expressing himself, that that's even more protected by the First Amendment, not less. But this is a case, Hills v. Davis, that should maybe shed light. This matter is before the court on plaintiff's motion for a temporary restraining order. Okay, so this is a preliminary matter. This is during the beginning of litigation. We haven't made any decisions. Let's see how the judge rules. Neither the public nor the media has a First Amendment right to videotape, photograph, or make audio recordings of government proceedings. So being stopped by a police officer, being raided by a police officer is not going to fall under that. You don't necessarily have the right to record your government meetings. So Hills v. Davis does not apply. It is distinguished from our case here. So not Hills v. Davis. We still have halfway to go here. So Virginia's 4th Circuit, 10th Circuit, 10th Circuit, Virginia, Wisconsin. What else is the 6th Circuit goes up to Michigan, Kentucky, and Tennessee. 5th Circuit, Michigan. Many circuit courts have determined that videotaping implicates the First Amendment when it is used to gather information about what public officials do on public property. Here, McKay is seeking to exercise this alleged right to record public officials, in this case, county judges. So no, that's going to be a different thing than police officers raiding your private property and you using your recordings of it. Texas, California, Maryland, Illinois. Illinois is not, nope, Illinois 7th Circuit. Indiana, Missouri, 6th Circuit. Officers have no First Amendment right to record interviews during police misconduct investigations. So the 6th Circuit says police can't record their own misconduct investigations. All right. And so that's, the end of what co-counsel on case text came up with for us there. And what that tells me is that there isn't a case in the 6th Circuit directly on point, finding that the First Amendment protects against this kind of lawsuit. It should protect against this kind of lawsuit, at least in part. Let's see what the other side has to say. Let's see what Ohio law has to say about the persona question. Do you have a right to likeness that is actionable in this case? I asked Case Text co-counsel this question. What are the key provisions of Ohio Revised Code Chapter 2741 regarding the unauthorized use of an individual's persona? Ohio Revised Code Chapter 2741 generally prohibits the unauthorized use of an individual's persona for commercial purposes. Specifically, it states that a person cannot use any aspect of an individual's persona for a commercial purpose during the individual's lifetime or for 60 years unless they obtain written consent. However, another section, 09, outlines a number of exceptions, such as for literary, dramatic, or historical works, or for material with political or newsworthy value. If a person violates the law, they may be liable for actual damages, statutory damages, or punitive damages. The statute directly addresses the research request, outlining the circumstances under which a person may not use an individual's persona. Except as otherwise provided, a person shall not use any aspect of an individual's persona for a commercial purpose. A person may use an individual's persona for a commercial purpose during the individual's lifetime if the person first obtains written consent. We know that already. Persona means an individual's name, voice, signature, photograph, image, likeness, distinct appearance, if any of those aspects have commercial value. Commercial purpose means the use of or reference to an aspect of the persona on or connection with a place, product, merchandise, goods, services, or other commercial activities not expressly exempted under this chapter. 2, for advertising or soliciting the purchase of products, merchandise, goods, services, or other commercial activities not expressly exempted. 3, for the purpose of promoting travel to a place. 4, for the purpose of fundraising. Exceptions. This work does not apply to the following: a literary work, a dramatic work, a fictional work, a historical work, an audiovisual work, a musical work, regardless of the media in which the work appears or is transmitted, other than an advertisement or commercial announcement not exempt under Division A1D of this section. B, material that has political or newsworthy value. C, original works of fine art. D, an advertisement or commercial announcement that is permitted by A1A, B, or C, which I guess A1A is going to be the literary work, dramatic work. And this is, A2. The use of an individual's name to truthfully identify the individual. This does say something more. Or the performer of a recorded performance under circumstances in which the written work or the recorded performance is otherwise lawfully reproduced, exhibited, or broadcast. The use of an aspect of an individual's persona in connection with the broadcast or reporting of an event or topic. And there's more, so let me copy this link. 4, the use of a persona of an individual solely in the individual's role as a member of the public if the individual is not named or otherwise singled out as an individual. That might apply. The use of a persona by an institution of higher education if a person was a student. No. The use of a persona if the individual... The use of the persona of an individual that is protected by the First Amendment to the United States Constitution as long as the use does not convey or reasonably suggest endorsement. This is it. I think this is the killer right here. So this is an exception to the first count, a use of the person's persona that is protected by the First Amendment to the U.S. Constitution as long as the use does not convey or reasonably suggest endorsement. I don't think Afroman's use of the police officer's picture on his t-shirts suggests endorsement. He's literally calling them Officer Lemon Pound Cake, apparently because the officer asked for a slice of pound cake that he must have seen while he was raiding the house. So these people raid your house and have the audacity to ask you for hospitality. No. I might be humane enough to let them use the bathroom or give them a glass of water. If they're having a medical emergency, I will tend to them as best as I would anyone, and I'll call an ambulance. But I'm not giving you my gosh darn lemon pound cake. What the heck? I mean, okay, it's no crime in asking, I guess, but geez. Okay, so we've got an exception here. It also says this chapter does not affect the rights or privileges recognized under the Ohio Constitution or United States Constitution. So, bam, I think we're done with the analysis of that. I think if we go back to the Afroman lawsuit and look at count 1, they're saying that the personas were not used in connection with any news, public affairs, et cetera, et cetera, et cetera, but they did not at all acknowledge those last parts of the law. Parts A1-6, I think it is, A1A6, and then A1B. And this has been in place since 1999, so it should be, clearly, what's the qualified immunity standard? Clearly established. It's been clearly established that law works that way. Let's check out the next count, invasion of privacy by misappropriation. I mean, I don't really need to go through the law as detailed, but it's going to be the same thing. And I don't see how there was any privacy violation. When we usually talk about a reasonable expectation of privacy. So let's say you're having a private conversation in a phone booth. Do you have the right to not have your phone conversation recorded by anyone while you are having a conversation in a phone booth with the door closed and everything? Yeah, you have a reasonable expectation of privacy. If you're in a restaurant sitting in a booth and you are speaking in hushed tones to someone, do you have the right to not have someone record that and publish it? Yeah, that's pretty arguable that you have a reasonable expectation of privacy. Do you have a reasonable expectation of privacy in your own home? Yes. Do your invited guests have a reasonable expectation of privacy in your home? Yes. Do your uninvited guests have a reasonable expectation of privacy? Does a trespasser have a reasonable expectation of privacy? Does a law enforcement officer in the execution of their official duties while serving a warrant and raiding your house have a reasonable expectation of privacy? No. In fact, quite the opposite. They would have seen the cameras. They would have seen that Afroman's wife was recording them. They would have known they were being recorded, and they would have known that they could do nothing to stop the recording and dissemination of the recording. And what we're just talking about here is, can you then transform that recording into a music video, clips of music videos, music, and merchandise? And I'm pretty darn clear that the recording is protected. The recording can be released of the security camera and the raid and all that. And that if Afroman made something expressive out of that, that is further protected. That this privacy law count, at least in count 1, definitely doesn't apply. We can do a little more of a look into counts 2, 3, 4, 5 here. But I mean, some of these are pretty ridiculous. Unreasonable publicity given to private lives. Were these officers' private lives given any publicity whatsoever? None. No, of course not. These officers are justly humiliated, are duly humiliated for their unsupported raid on Afroman's house. What were they looking for? Can someone enlighten me? Yeah, what's a phone booth? They searched his home on suspicion of drug trafficking and kidnapping, but found no evidence and filed no charges against him. He says they kicked down his door, broke his video surveillance system, stole money from him, and frightened his family. It's hard for me to believe the police side of the story automatically there. Well, first, if they had no evidence and filed no charges against him, that seems like a pretty botched raid there then, buddies. I really want to know the support for that search warrant. Was there an anonymous phone call? How many anonymous phone calls? What was the evidence that supported this warrant? So, injunctive relief, is that a count? That's a remedy. As a remedy, yeah, you would ask for an injunction because your plaintiffs are suffering a irreparable injury. In this case, it's irreparable because they did something stupid and they're being made fun of now. I'm pretty sure that that's Afroman's First Amendment right to hit back using his First Amendment expression. So I'm very skeptical that there's basis for a injunction here. Now, who knows? Things could happen in Ohio Common Pleas Court that contradict the First Amendment United States Constitution right. Invasion of privacy by misappropriation. Likenesses have been misappropriated. Yeah, it's the same thing. It's the Toyota billboard example. I'm sorry, I don't mean to pick on Toyota. I'm sure their cars are great, and I'm sure their dealers would not do something like this. But imagine someone put up a Toyota dealership ad that had these officers' likeness in it. And it was, come to your local Toyota dealer, supported by your local police. And these officers did not give permission to have their perfectly legal photos put up on this billboard. That's where you're crossing the line. It's not you're not expressing your First Amendment rights. You're not creating something. You're not expressing your right of free speech. You are using these police officers' images to endorse your Toyota dealership. That would be a much clearer example where invasion of privacy and right to likeness and all that would apply. But we already looked up that the unauthorized use of an individual's persona has a major, major First Amendment exception in it that specifically addresses this case, in my opinion. So that should also be the death knell for the rest of these counts. And certainly the First Amendment preempts all of these state law claims. So I'm pretty sure Afroman has a very decent First Amendment defense. Now, I'm not an Ohio lawyer. Maybe there's some nuance of Ohio law that I've missed. So, big disclaimer that this is just a fun example or fun dive into the legal research that I would do. And whether or not an AI can summarize the cases, because I thought that was pretty good. I was actually impressed with the AI summary of it. I'm not impressed with the prices they're charging for that, but that's between Casetext and their customers. And I'll continue to try to do something like this, although I'm probably not going to be paying for Casetext's very expensive summaries, when most of that research can be done with just a simple search that I already pay for. So the thing I'm most concerned about with the Afroman case is the images on the T-shirts. Does that make it seem like those officers are endorsing the music video, the album, the merchandise? Or is it Afroman expressing his displeasure at being raided and trying to make the best of a situation? I don't see the commercial use playing that much into the First Amendment rights. If somehow the court lets the plaintiffs pierce the First Amendment rights and go after the invasion of privacy, then you're definitely going to see lots about what the lines of commercial purpose are. And we've already seen rights be rolled back by today's Supreme Court. So it's also possible that these plaintiffs' attorneys are hoping that even if they lose at the state level and at the circuit, the district court level, and maybe even the circuit level, that they would still have a possibility the Supreme Court would roll back some First Amendment protections, having said that they went too far or weren't original to the Constitution or something like that. I'm pretty sure that the originalist argument won't work very well, because you still had a right to free speech back at the late 1700s during the framing and founding of the nation and the drafting of the first U.S. Constitution and the amendments and all that. So I think you could still mock your officials back then, and it was First Amendment protected, so maybe it won't be as easy to roll back as they did in Dodd. Anyway, let me know what you think of Afroman's lawsuit here and the Streisand effect that's currently visiting the officers in this case. I don't think that there's any way to put the horse back in the barn here. Let me know what you think in the comments below.